Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more. This week was important. This week, finally, because it's been years we've been trying to get important Second Amendment cases before the United States Supreme Court. And they've been rejected for one reason or another. Oftentimes, we don't really know why. But this week, we had the oral arguments for the New York State Rifle and Pistol Association case, challenging the licensing scheme that New York has for carry permits. Basically, the way that works is you apply for a permit and you get denied, period. That's it. Unless you are well-connected or wealthy and can pay somebody a lot of money or give somebody a Rolex or whatever it takes. A lot of reports of different things like that. Major case. It was fascinating to listen to it, and helping me to explain it, or actually to explain it to me, to figure out what happened there and try to clear some of the muddy waters. Don Kilmer is a law professor, a lawyer specializing many times in civil rights and Second Amendment cases. Don, welcome. How are you, sir?
I'm doing well. Congratulations on your harvest this week.
Yes, indeed. That's all in the freezer now. So that's the fun part. I like getting it, I like cutting it up, and then I like cooking them. So I do the whole thing, field to fork.
All right, then.
So, all right. Did you listen to I imagine at this point you listened to the oral arguments.
Yeah, I did. I didn't listen to it in real time, but I did listen to it, the recording afterwards. I usually like to wait until they actually produce the transcript so I can read along with listening to it. But that's
good idea.
Just because and now for your listeners' edification, it's case number 20-843. So that's important. If you want to go onto the U.S. Supreme Court's website, it's a .gov website. Everybody in the country has access to it. So you can get these documents, you can get a copy of the transcript, and you can download the audio recording of the oral arguments yourself and read along and listen to it. Now, there may not be as many nerds in your audience as I am, but for folks like me, this was the Super Bowl, the Stanley Cup, and the World Series all rolled up into one.
Absolutely. I mean, and I listened to it real time,
Okay.
I love the idea of going back and doing it with the transcript, because there are clearly things you miss when it's going by, because sometimes I was going, wow, it's like I wanted the crowd to cheer several times. It's like, holy cow, did you see that? It's like watching a football game. It was amazing.
Yeah. I'll tell you one thing. Let me give you a gut level, almost theater critics takeaway from this. Okay. I'm always impressed with Paul Clement's work. I mean, the man is a stellar at oral argument. Reading his briefs is like reading clarity itself.
Well, let's explain. Paul Clement was a former U.S. Solicitor General, and he was the one arguing the case for the New York State Rifle and Pistol Association.
That's correct.
Okay.
That's correct. Mr. Clement is a true almost artist when it comes to these kinds of arguments and these kinds of high profile cases. But when your audience gets to listen to this in the audio, or even you can pick up a little bit on it in just reading the transcripts itself, the almost mental chaos that I was getting from the other side.
Oh, Barbara Underwood
was when you listen to it.
Barbara Underwood was completely unprepared. The Solicitor General for New York, she was out of her depth from the moment she opened her mouth.
Yeah, it's almost as if she was like a wave of her hand with don't trifle me with things like the Second Amendment, and she couldn't be bothered to be prepared for the case. Now,
yes.
The other fellow, the U.S. Solicitor General, arguing by permission, he was an effective advocate. He was wrong, but he was an effective advocate at least. But Miss Underwood she literally got called out on this. There's this kind of controversy, and I know this might be kind of wonky for your audience, but this Northampton statute, what they're talking about here is in England, before the United States was even a sparkle in anybody's eye, had a statute that was passed by a king. I'd have to look at my history book or notes to know exactly which one it was. But it was a statute that said writing about the country with unusual weapons or even common and ordinary weapons that was in a means or a way that was intended to terrify people was illegal. Okay, that's the gist of the Statute of Northampton. Well, we have a statute just like that today. It's called brandishing. Okay, mm-hmm. You cannot use weapons to intimidate or frighten people. If you're carrying a weapon for self-defense, there's obviously a way to do that, and if you do it wrong, you can be prosecuted for it, just like you could in the state of Idaho where we live. Okay, one of the freest states in the country when it comes to exercising your Second Amendment rights. You still be prosecuted if you're drunk and brandishing a weapon and scaring people on the city streets.
Okay.
But the other side now wants to cite the Statute of Northampton because they've latched on to this text history tradition of the Second Amendment, where they think the Supreme Court is going on how to interpret it. And they think that, well, the farther back they reach in history, the more credibility their arguments will have. So what they end up doing is they end up cherry picking the Statute of Northampton.
Well, more than that, and if you leave out an important word, you get caught on it, don't you?
Well, that's what gets me to the next point. Is that so they're relying on the Statute of Northampton, and then what the state of New York did in citing some sort of pedigree for its law, that this is a long-standing law, it's existed forever, it's no big deal, nothing to see here, move on, was that they cited these founding era legal reference guides for sheriffs, and cited in the government's briefing, just as Alito actually called out Attorney General Underwood on this. Well, your brief says that the legal reference guide says, quote, arrest all such persons as in your sight shall ride or go armed. They've taken that to mean that, there's always been a law in America, even since the Revolution and even before the Revolution, that said it was allowable for the government to arrest people who went armed. And then Justice Alito pointed out to her, except you left out a word.
Yep.
You left out the word offensively. You shall arrest. The actual legal text is, you shall arrest all such persons as in your sight shall ride or go armed offensively. And her argument, her counter to that, instead of just saying, well, I guess we blew our brief, I guess I made a first-year law student mistake, and I would get thrown off of the law review if I did something like that, is to say, well, guns are offensive.
Well, and Alito comes back and says, but the argument you're making is what it actually says is exactly the opposite of what you're saying. I mean, he called her out right there on it.
Yeah, this is something that has frustrated me and other Second Amendment litigators to no end, and that is that the legal scholarship on Second Amendment briefs has to be perfect. It has to be perfect. Yet there is all manner of sloppiness and slapdash work that is done by lawyers, government lawyers on the other side, that judges will forgive, that judges will accept. The interesting thing is that a couple of my colleagues, George Moxery and Dave Coppell, published a law review article this summer about the exact same mistakes that were made in the Ninth Circuit's opinion in Young versus Hawaii, where legal citations were truncated, where statutes were interpreted that didn't mean what they said they meant if you actually went to the original text. So this is a battle not just for the Second Amendment. It's also a battle for, in some ways, judicial integrity. Now, I do not mean to imply that all lawyers defending government laws, or even lawyers that I oppose in court, are bad guys. Okay, but there's a certain tolerance by the courts for sloppy scholarship on some of this stuff.
Okay, you're calling it sloppy scholarship. You have to play in that world because you are a law professor and a litigator. I call it lying and cheating. So there you go.
No comment, brother.
You hold on to that thought, Don Kilmer. We're going to take a quick break here. We'll come back, and then I'm going to get your take on, okay, what actually happened here and what is actually at stake? We'll go ahead and read the tea leaves, and we'll step out there, and at least I'll make the prediction. I don't know if he will. A little bit more time on this because this is a very important case. This case is at least as important as the Heller decision, I think, the case that was argued before the United States Supreme Court on Wednesday of this week. We're talking with Don Kilmer, law professor, litigant, knows this stuff. Don, one of the things that hit me as I was listening to this was Chief Justice Roberts, who has been somewhere between iffy and maybe not even strong on the Second Amendment. He was going at Underwood on some of this stuff, and he was sounding like a Second Amendment guy. That wouldn't surprise me.
Yeah, that when you talk about trying to make a prediction of how this is going to turn out, this prediction becomes stronger that this will favor, Paul Clement's client, is the fact that Justice Roberts was A, so engaged, and B, seemed to be implying that that New York has this wrong. He's not necessarily. I don't know if he's necessarily ready to say, well, every state should have shall issue like Idaho, but I think he's ready to say something like New York's doing it wrong.
And in New York, going over the basics, to get your permit there, your carry permit, you have to show that you have proper cause, which is almost never agreed upon by the bureaucrat who checks you out. And I did appreciate the fact that finally we have arguments before the Supreme Court where they're saying you would never do this for the First Amendment. It would be anathema to say you have to go to a bureaucrat and say, may I please have my First Amendment rights? And them saying, no, I'm sorry, you're just not worthy. You don't really have a good need for them. But yet they're doing it for the Second Amendment. To see them actually argue the two of those together, I was like cheering them on the whole way.
Yeah, it's appropriate to cheer, but keep in mind here, and here's the intellectual ammunition for your audience. The other side is always going to want to come back with, yes, but the First Amendment is regulated to, or it's limited to. And they'll point to things like parade permits or time, place, and manner restrictions. So that, if you want to hold a rally, in a park or something like that, it's, you have to get the permit for the day. Or you want to hold a parade,
sure,
you have to get a parade permit. But they miss the fundamental distinction. But the government in those regulations is not saying you can't exercise the right. The government is saying for you to exercise the right, we have to do something. We might have to have extra security. We might have to close some roads for a few hours, or inform merchants that the street's going to be closed where you're going to have your parade. It's not that you can't have the parade. It's that we have to plan it because you're going to be using city resources for it or something like that. And what they're going to try and do is analogize that in the Second Amendment. Well, you're using city streets, and therefore we get to regulate the right. Well, that's where the permit comes in. The government gets to step in and say, well, are you a felon? Are you a violent person? Okay. Do you have a history of mental illness? Because we need to know that before you get to exercise the right. It's not a opportunity for the government to deny the exercise of the right. It's an opportunity for the government to make sure that the right does not impact the rights of other people.
Okay. As you read the transcript, you listened to the oral arguments, do you come away with a general sense or a feeling after all of this?
I come away out very optimistically that the court is going to say that New York is doing this wrong. Now, the specific remedy could be simply strike down the New York law and tell them they need to do it better. The court could remand it and say there need to be findings of fact in the trial court. There needs to be instructions issued on how this law, maybe a trial on whether the law can be implemented constitutionally, and give New York a chance to justify, could they enact regulations that would fix the statute? But I have a sneaking suspicion the U.S. Supreme Court is simply going to say this law is unconstitutional, in the way that it allows absolute discretion to local government officials to say whether somebody can actually exercise a fundamental right or not. This is not a regulation of a right in a public space. This is a cancellation of a right, or the conversion of a right, from
to a privilege,
a right to a privilege or something. Yeah.
And one of the things that when people listen to this or read it, there are a few things there that if you're paying attention, you're going to get a chuckle or two, or maybe it's that whole head shaking deal. When Justice Breyer says, "You mean anybody can have a gun can carry a gun just for fun?" I'm thinking, what? Yeah. What did he just say?
Yeah. Some of this has to do, though, Tom, with people who, and one of my other favorite social commentators, Victor Davis Hanson, comments on this a lot. That this is an elitism that we get from people who live in a bubble. They don't go out in the real world. They don't walk the city streets. They don't walk a country road or very few people I know carry a gun for fun. Okay, they're heavy, they're bulky, and there is a tremendous responsibility that I have a right to exercise. But it's not the same thing as saying that it's necessarily fun. Now, when I'm out shooting at the range or plinking with friends or out hunting or sighting in a new rifle or something, yeah, that is fun.
Well, but no, you understand, of course, and I know you do, that he was, with that comment, he was being utterly dismissive of the whole concept.
Yeah, he was being as dismissive as the New York Attorney General. That this Second Amendment is a frivolous, anachronistic argument. That's how they think, right. And that they really are exasperated with having to deal with the Second Amendment, which means they're exasperated.
It's like they're saying, "Oh, this again? Yeah, are we still talking about this thing?"
Yeah. Yeah. Oh, yeah.
So probably.
But see, this is what we mean when we say fundamental rights. If they're fundamental, that means we must always be on guard. We must always be vigilant for their protection. So yes, they should be talked about all the time, and every time there's even a threat of violation.
So probably looking at June would be my guess before we get a decision on this.
It could be could be as early as March. Could be early as March, but it depends on who ends up getting assigned to write the opinion. It depends on whether it's going to break down strictly as a majority opinion and dissent, or whether it's going to be a majority opinion, a concurring opinion, and a dissent. Mm-hmm. As we know, sometimes Justice Thomas, who I greatly admire and love hearing his voice on the audio.
It was terrific.
He sometimes takes a different look on things and writes an interesting concurring opinion that itself is informative and provides context.
Well, what's at stake here, just so people understand, is that we have several states that are may issue states, where as opposed to the shall issue, we have 43 states that are shall issue. And what they're saying is that these other 7 states, they're going to become shoot 'em ups and Wild West and everything else, because they're going to end up being just like the other 43. So may issue may end up going away. Don, I'm just flat out of time. We could do this. Let's do it again, but just the two of us over a glass of brown liquid. How's that?
Sounds good to me.
All right. Don Kilmer, thank you.
And maybe some of that venison you got.
Oh, okay. That's a deal. We'll make that happen, okay? Sounds good. All right. Look, thank you so much, and I really appreciate you. You always help clear the muddy waters for me, because I need all the help I can get.
Take care, brother. You're too modest.
You take care of yourself. Fascinating case. It is it's important. It's as important, I think, honestly. It's the second half to the Heller decision. Keep and bear. We got keep with the Heller decision. Now we're going to get fair with this one.